Thank you, Soumya. Honorable Vice Chancellor, distinguished resource persons from all across the world, dignitaries, ladies and gentlemen, a very good morning to all of you. I should also add on very good afternoon as well as very good evening, depending on from wherever you are actually watching this event. First of all, I should thank all my friends and colleagues who have graciously accepted to be part of this particular conference. So we will be having this one-day discourse on the very important topic of the national space legislation. And if anyone want to enlist the top 10 space law experts across the globe, probably these 8 names would figure in all the lists, whatever list it might be. So that's the kind of actually the response I could able to get, and I am very grateful to all my friends as well as the colleagues who have accepted to grace this occasion with their presence, and also actually they will be giving their own input in terms of actually how exactly the national space legislation need to be drafted. I should also be thankful to all the participants. Let me welcome on behalf of the NUJS as well as on behalf of the Center for Aviation and Space Law, once again, let me join hand with our Honorable Vice Chancellor to welcome you all once again for this particular conference. I'm pretty sure that this one-day discourse would give us a lot of insight, and I'm very sure that towards the end of the day, all of us would be enriched very much in terms of the knowledge of the national space legislation. In this opening remarks, I will be speaking on decoding the varying approaches to the national space legislation. Of course, let me also tell you that in my next maybe 18 minutes presentation, I will not definitely be taking a position as an organizer. So being an organizer, probably it is not advisable for me to take a position on the different approaches to the national space legislation. I will just give the outline of what kind of approaches have been taken by the different countries, and I will leave it to the panel as well as actually the paper presenters to put forward their own views about the current developments in the national space legislation and what should be the future of the development. So please excuse me if I don't take a position with respect to these aspects. To start with, starting from 1957, there has been a lot of developments which have taken place both in the field of space technology as well as the space law. After the entry of Sputnik into the outer space, one of the major questions was, what is the law which is governing the outer space and celestial bodies? The immediate response came from the UN General Assembly. There have been a series of resolutions which have been passed by the UN General Assembly for the purpose of regulating the activities of the states in the outer space, and also for the purpose of, in a way, giving a direction for the future development of space law. Of course, this first phase of the development has been the soft law, as the UNGA resolutions are non-binding norms. So subsequently, between 1967 and 1979, 5 major treaties were entered into. So from soft law, there is a shift to the hard law in the form of the 5 treaties: the Outer Space Treaty 1967, the Rescue Agreement 1968, Liability Convention 1972, Registration Convention 1975, and finally the Moon Agreement 1979. But unfortunately, after the Moon Agreement, there was again no consensus in terms of the treaty making. So therefore, the third phase of the development after 1979 saw the adoption of certain set of principles and also a declaration ultimately in 1996. We have the principles in terms of direct television broadcasting 1982, remote sensing 1986, and finally the nuclear power sources, principles on nuclear power sources in outer space 1992. And in 1996, a declaration was entered with respect to the benefit and interest of all the countries, carrying on the activities in the interest and benefit of all the countries. These are the kind of developments which have taken place in the international level for regulating the space activities. However, international regime has been predominantly oriented towards the regulation of the state activities in outer space, because during 1960s or 1970s, whenever we had the treaties, at that time, states were the only players in outer space. So focus is only in terms of regulating the state-oriented space activities in outer space. Of course, we have got certain fundamental principles which should govern in any activity in outer space. Like if you look into the space treaties, we have the principle of province of all mankind. We have the principle of freedom of exploration, use, and scientific investigation available to everyone in outer space and celestial bodies. We have principle of national non-appropriation, peaceful uses of outer space and celestial bodies, then environmental protection principles, principle regarding the jurisdiction and control with the state of existing, liability of the launching state, appropriate state's responsibility, and even with respect to the rescue of the astronauts and all, we have the principle of astronauts as invoices of mankind. So that's how certain fundamental principles governing the space activities have evolved over the period of time in the international space law regime. But towards the end of the 20th century and in the beginning of the 21st century, we find rapid development in terms of the private space activities. A lot of private entities started to show interest in terms of the commercial activities in outer space. That is why regulating the private space activities attained significance in the modern period of time. And unfortunately, as the space treaties or the international space law is oriented towards the state activities in outer space, there was a kind of a vacuum in terms of governing or regulating the private space activities. This is why the national space legislation attained significance. We wanted national space legislation for the purpose of ensuring that the private space activities are not carried on chaotically and there is some order in terms of activities in outer space. Currently, we can see that only a very, very handful of the states who have adopted the national space legislation. Of course, when I'm telling about very few, only a handful of the states, I'm telling about those who have adopted the comprehensive national space legislation. Otherwise, some rudimentary norms have come into existence in several states, but a comprehensive legislation we can find only in limited number of states. In that, I can find that there are different kinds of approaches, which vary from a kind of a commerce-oriented approach on the one hand to a somewhat balanced approach. When I speak about commerce-oriented approach, I say that the state is thinking in terms of intensive privatization, thinking more in terms of actually more and more commerce, rather than actually some of the principles of the space treaties. But on the contrary, there are also certain states which are trying to strike a kind of a balance between the international space law principles as well as the commercial interests of the private entities. But of course, I'm not agreeing that it's a fair kind of a balance. There is, of course, they're struggling to strike a balance. That's what is the appropriate term which I can use. So it's not that there is an absolute balance. There is an appropriate model which is available for the purpose of striking a balance between the international space treaty principles as well as the commercial interests of the state. Now, the commerce-oriented approach, I would like to point out the United States position. The United States position. Since 1958, when it passed the first legislation in the form of NAS Act, US has passed several legislation which are all directed towards the more efficient commercial utilization of the outer space. It's more in terms of commercial utilization. So they want to promote as much as commercial activities in outer space as possible. The 1958 NAS Act established the primary agency in the United States, the NASA, which has got enormous powers in terms of not only carrying on their activities, and it also has got enormous powers in terms of actually having the partnership with the private players, going for the commercialization, so on and so forth. The subsequent laws, which are also amended over the period of the time, like say Commercial Space Launch Act 1984, then subsequently there was a change in the form of Commercial Space Act of 1998. All of them were directed in terms of more and more commercialization of the private activities. Like space launch is made available for the private players. They can also operate the satellites in outer space independently. So all these kind of developments have taken place out of the Commercial Space Acts, which have been actually passed before the beginning of the 21st century. Then we have Title 51, Chapter 509 in the United States, which has also been amended time and again depending on the requirement. And it specifically speaks about the licensing of the private space activities. The procedure for the licensing, authorization, requirement of the insurance coverage, then maybe the demonstration of the financial capability. All those different aspects are mentioned in Title 51, Chapter 509. And in terms of liability also, US has brought in a kind of a three-tier structure for the purpose of liability for damage caused by the private players' activities. At the first tier, the insurance coverage would come into picture. At the second tier, the state would take the liability to a certain extent, and then over and above that, the private players may be held liable to pay the compensation. So that's how a three-layer liability regime has also been brought in, and it is also in a way for the purpose of incentivizing the private place activities, because state to a greater extent cushions the liability in the second stage. Next, 2015 onwards, there has been further efforts for the commercialization of the space activities. In 2015, the United States passed the US Commercial Space Launch Competitiveness Act, which had the part in terms of exploiting the resources from the asteroid as well as from the outer space. Space resources and asteroid resources can be exploited, and also the private ownership of these resources have also been conferred under the 2015 legislation. Subsequently, also it was tried to be supplemented in a 2018 draft, which is yet to come into force. There is also actually Space Enterprises Act, which they are basically trying to adopt, but it is not being actually accepted as of now. In 2020, US has also come up with Artemis Accord, wherein it has sought cooperation from other countries for the purpose of exploiting the resources of the moon. They are planning to go back to the moon and exploiting or exploring the resources and other activities in the moon and other celestial bodies. They are primarily asking for the cooperation. Some states have already signed in for the Artemis Accord, and they have already promised to cooperate with the United States regarding the activities on the moon. 2017, Luxembourg has also followed the pursuit of the United States. It has come up with the law on the use of resources in the space 2017, wherein also the private ownership has been made allowed. I think on this actually we have Professor Mahulena Hoffman, who will be discussing this legislation and the subsequent development, whatever have happened in the Luxembourg. Let me not actually take a call on this at this moment. All these developments in terms of the commerce-oriented approach have brought in questions with respect to compliance with Article 2 of the Outer Space Treaty. There have been a lot of academic debate with respect to the contravention of Article 2, which prohibits the national appropriation by claim of sovereignty, by use of occupation, or by any other means. So scholars are divided in terms of saying that whether it is permissible or not permissible within the ambit of Article 2 of the Outer Space. Of course, I think other resource persons will be able to actually highlight more on this, and they will be able to take a position on the violation of Article 2. Then, in 2020, US has also passed the National Defense Authorization Act, wherein US has also created a separate force in the form of a space force. It will be an additional wing of the United States military. So a new force has been created in the form of the US Space Force with the National Defense Authorization Act of 2020. This has also raised the eyebrows of certain critics who basically argue the possibility of violation of Article 4 of the Outer Space Treaty. Wherein under Article 4, there is a clear-cut requirement for the peaceful users, and plus there is also actually the requirement for de-weaponization of the outer space and all. Of course, there are limitations of Article 4. I will not discuss them here. But the critics basically argue that there may be a possibility of violation of Article 4 by virtue of the creation of the US space. So these are all the kind of the developments which has taken place in the United States, which seem to be a more kind of a commerce-oriented approach, wherein their basic principle is more in terms of promotion of the competition rather than the regulation of the private space activities. So if you promote the competition, it will be beneficial for the interests of the people. That's what is the basic premise behind the commerce-oriented approach. Now, on the other hand, we find certain states, I should say, struggling to strike a balance. They're struggling to strike a balance between the fundamental space law principles and the commercial interests of the private entities. I should refer to Russian legislation and UK legislation. These to seem to come within the ambit of this struggle for a balance, that kind of an approach. If you look into these legislation, you can find that they explicitly enumerate that the private players, when they carry on the activities, they should respect the international commitments of the respective state. Right? They should comply with that. Otherwise, the licenses will be cancelled. So, such a kind of an explicit reference has been made in these legislation, which in a way indicate that they would like to respect the international space law principles, and plus also the private players should also comply with those principles. We can find provisions in terms of demilitarization. For example, if I have to quote from the Russian legislation, Article 4.2 of the Russian legislation has a provision in terms of demilitarization. But again, if you look into the Russian legislation, the Ministry of Defense has got the authority to go for the militarization or military activities in outer space, but the private players have been prohibited under Article 4 legislation. Apart from that, we can also find certain provisions on the environmental protection. Of course, not foolproof provision. So, some sort of a provision in terms of debris mitigation we can find in these legislation. And another interesting thing which you can find in the Russian legislation is that it explicitly allows a right of innocent passage in its airspace for the purpose of the launch as well as the return. For one-time launch into the outer space as well as to the return into the Earth surface, the Russian legislation has got a specific provision allowing the right of innocent passage for other countries' space object, which should in a way be considered to be the part of the principle of international cooperation, which is also a bedrock principle under the space treaties. That's why these countries' legislation in a way show a kind of a struggle for striking a balance between the international space treaty principles as well as the commercial interest of the private entities. In between these two kind of approaches, like the commerce-oriented approach and a struggle for striking a balance, I can find various other approaches of different countries. We have Australian legislation, or maybe we have certain legislation passed by the European Space Agency countries, or even for that matter, the South Korea, the legislation in South Korea. So they will all indicate the different phases of the approaches between actually a commerce-oriented approach and a struggle for striking a balance between the international space treaty principles as well as the commercial interest of the private entities. So that's how we are having the varying approaches in terms of the national space legislation. Finally, let me just briefly point out about the Indian position. We have got enormous developments in terms of the space activities. Over the period of time, there has been tremendous development. We have also actually achieved the feat of Chandrayaan, Mangalyaan. So there has been a lot of developments which have taken place in terms of the space. However, all these are predominantly state-oriented. I'm not saying that the state is the sole player. There have been a lot of actually the startup companies which have come in India. Currently, actually, a lot of business is going on in the space sector by the private players. But primarily, the operation of satellites, the launch activities, all these kind of things are predominantly the state-oriented activities. So the private players are involved more in terms of the incidental space activities, rather in terms of the direct launch as well as the operation of the satellites. There has been efforts made in terms of the privatization. Anthris Corporation has been established in 1992 as a first step in terms of promoting the private participation. But it had a limited mandate in terms of more and more commercializing the ISRO's space capabilities with the private players. So that was a kind of an approach with the Anthris Corporation had. But unfortunately, with the Anthris divorce crisis, there has been a lot of problems. You people must have heard about actually the litigation between Anthris and divorce. There is an arbitral award against the Anthris Corporation, wherein a huge compensation is liable to be paid by the Anthris Corporation to the. But whatever it may be, Anthris was the first step in terms of promoting the private participation in the space activity. 2019, a new body in the form of New Space India Limited has also been established for the purpose of furthering the commercialization. So, what exactly is the area of operation? Is there a difference between Anthris or New Space India Limited? There has been actually debate over that. some of the critics believe that New Space India Limited is going to take over the Antares Corporation, but the position is not very clear what would happen in the future. So, for the further intensive privatization, New Space India Limited has been established in 2019. As far as the legislation is concerned, since the beginning of the 21st century, a lot of efforts have been made for passing the national space legislation. There have been deliberations, there have been drafts which have been prepared, and ultimately in 2017, the draft of space activities bill was also prepared and opened up for the public comment. Of course, there have been a lot of actually the limitations of the 2017 bill. Consequently, it has not seen the light of the day. And of course, ISRO and Department of Space is heavily involved in terms of fine-tuning the 2017 draft and to come up with an appropriate national space legislation in the course of time. So developments are going on in terms of adopting a national space legislation. Finally, during this COVID-19, as all of us are aware of, there has been a huge economic problem or economic crisis which has been faced during the COVID-19 era. And in order to overcome the economic crisis, the Prime Minister has already announced different plans. One of the major plans is in terms of privatization of the space activities, more intensive privatization of space activities. For this purpose, IN Space is supposed to be established, Indian Space Promotion and Administration Center, which is to be established for the purpose of permitting and overseeing the space activities in accordance with Article 6 of the Outer Space Treaty, requirement of authorization and continued supervision. So IN Space is supposed to carry on these kind of activities. There are also proposals for the sharing of facilities, the ISRO facilities with the private players, and establishing the facilities in the US premises, the Department of Space premises. The private players can, after complying with certain requirements, they can establish the facilities. There will also be monitoring part. There will also be ISRO industry interface, public-private interface. With respect to all these things, the guidelines will be prepared, and then there will be more extensive privatization, which will be attempted out of all these. So this is how we are actually situated at present. And I think probably in the last 20 minutes, I could able to tell you that there are varying approaches to the national space legislation. We are having different states at different stages of the pendulum. And consequently, one thing which is problematic is that there is no harmonization. There is no harmonization. There are different approaches which might create a kind of a confusion or chaos in the outer space activities. Of course, when I speak about harmonization, I also understand that it is not possible to absolutely have a one uniform law. That is not possible, right? So we need to have certain fundamental principles common in most of these national space legislation. That's what we have to strive towards, and these discourses like the conferences on the national space legislation definitely help us in molding our future national legislation in an appropriate manner. So that's all. Let me once again welcome you all to this particular one-day discourse. Thank you so much for all your participation and cooperation.
Everybody hear me? Well, thank you everyone for hosting this conference. I appreciate it. Appreciate the invite. Good to see some colleagues I haven't seen in a while in this COVID world. Nice to see you, Dr. Sandeep. Good to see Dr. Joanne again, John Gabrinowitz, and there's others. Yes, it has definitely been a while with the COVID world. At any rate, I was going to talk on something slightly different. It's not directly on the subject of space law. It obviously addresses it in part. But this is a project that I initiated. A couple of years ago. I launched the Astropolitics Institute. I'm the chief academic editor of the Journal of Astropolitics that maybe many of you are familiar with, published in. And created around that the Astropolitics Institute to try to further advance the state of the field of astropolitics. So as I was mentioning with the Institute, so I launched the Astropolitics Project, which is an academic publication that's moving forward through the Journal of Astropolitics. And potentially in the future, this will become a book project, trying to essentially better define the field of astropolitics, and to kind of examine the state of astropolitics, looking essentially kind of the ecosystem of space. As kind of mentioned here on the document I'm showing everyone, astropolitics really encompasses a broad range of factors related to the space enterprise, from civil, commercial, and military space activities, and really examining, in addition to the legal, which is the focus more of this conference, looking as well at the historical, strategic, the political, bureaucratic, organizational, economic, commercial, and business factors. So it's very, very broad in that regard. Trying to really look at the, what I would call the soft side of the space enterprise. The space enterprise is largely an engineering and scientific undertaking, and astropolitics really is an examination of the factors that affect that enterprise, all the factors that aren't directly related to the engineering or the science. I wanted to highlight for everyone a number of the different themes that is the focus of this project, and we can leave some time for any questions there may be, or interest in further exploring some of these themes. Just to quickly highlight some of these themes, these are the themes that have been defined by working with a number of folks throughout the world, experts in this area, and these are kind of the themes of the Astropolitics project. So one particular theme is the strategic orientations of space powers. Astropolitics itself kind of emerged out of geopolitics and geostrategic considerations, and considering what are the strategic orientations of space powers is something that's very, very vital to understanding the kind of the geopolitical landscape and the geopolitical environment in the in connection with the space enterprise worldwide. The space powers really have a high strategic priority on space. They see it as a strategic necessity to project a number of elements, from power and security to growing emphasis on looking at space for remote sensing activities and having that support sustainable development activities, environmental science, communications, very, very vital for that. Very, very important in the civil sector as well, with GPS technologies, and clearly a growing commercial sector that's not only in partnership with government on a contractual basis, but also engaging in government and direct public-private partnerships, and a great degree of privatization of space activities that are emerging, which really lends itself to the robustness of industrial bases among space powers, and how those industrial bases are fundamentally tied to the space enterprise that those space powers are undertaking. So the strategic orientations are really a very important area to understand. Another important area is the commons of space and the boundary problem in space in terms of space governance. Where does space begin? Property rights in space. Space is largely established as a commons with free access and free use of the space environment. There is a big emphasis on this through international space laws, was mentioned earlier in the conference today. The Artemis Accords have committed themselves to the commons of space approach, but it still presents a boundary problem in terms of future potential claims of property rights in outer space, whether on celestial bodies, asteroids, property rights on the lunar surface or Martian surface, issues of interference. Clearly a number of fundamental issues that still need to be addressed within policy and law in relationship to the commons of space. Do we further extend the commons into the common heritage of mankind approach, which has been done with the law of the seas and the deep seabed as an example and an analogy? So a number of questions, a number of issues that need to be addressed in this regard. addressing the congestion problem in space, the debris problem, a lot of issues. We have a tragedy of the commons in some ways if we look at the orbital debris problem. So a number of key issues, fundamental issues, are addressed within this particular area. Moving down, we have the shift of authority, which is very, very interesting. As we have a growing non-state space sector, a growing privatization of space activities, there is the thought that you're getting a push from the privatization of space activities on government. If you look at kind of what's going on in the United States with the great degree of privatization going on, this could fundamentally change the relationship and the dynamic between national space agencies and the private sector. The private sector is much more mature, capable of space launch activities not only to low Earth orbit, but to the lunar surface and Martian surface into the future. How will this change the nature of what space agencies get involved with? How will this change the nature of public-private relationships, government contracting of services? We already have seen a seismic shift in the United States, as an example, where the government now is contracting for commercial services, where space exploration technology, as an example, is operating, helping to train astronauts, launching astronauts in the International Space Station on contract to NASA, where NASA is kind of a secondary partner in that relationship. So it opens up a whole new relationship here as we're beginning to get this shift of authority to some degree away from state actors to private state actors. And what does that imply for the policies and laws, and how do the policies and laws need to evolve with that trend that's occurring? Civil space issues. What are the key civil space issues among space powers and among developing and emerging space powers? Joanne Gabrinowitz today talked about some interesting civil space issues in relationship to remote sensing. Sandeepa Bhat talked about some of the licensing and legal issues. A whole range of civil space issues that need to be addressed. These kind of interrelate with some of the earlier things I talked about with the commons of space issues, authority issues, addressing, what is the role of the space enterprise in the civil domain? How are we going to make the most effective use? What are the value-added services? How are we going to leverage that in the space environment? And how does this contrast and play with developing and emerging space powers and the relationship therein? There's a big focus on how developing and emerging space powers can be brought into the fold of the space enterprise. We're seeing a very interesting development, for example, just to give one example here, is within the United Nations and international space venues, such as the International Astronautical Congress and the United Nations Office of Outer Space Affairs, an emphasis on how we can bring in developing and emerging space powers into the fold and space enterprise through looking at space applications to achieve sustainable development goals that the world's agreed upon, as one example here. Moving forward here, trends and developments in commercial space. I mentioned some of those clearly with the change in the privatization, and how is that going to change the way in which we're going to approach space exploration. I think a very interesting prospect is, are private space actors going to be involved in space exploration activities themselves? And I think we're beginning to see that with Artemis, with potential future human missions to Mars, that space exploration technologies has expressed a strong interest in, and has really begun to develop the hardware to put humans on Mars, probably by the end of this decade or within 10 years or so, or somewhere in the 2030s. What's the nature of international space cooperation and competition? How do we balance that? Most of what's done in the space arena is very cooperative. there's a lot of international space cooperation going on. The International Space Station is a great example within human space flight and human space exploration. The Artemis program that NASA is advancing is taking an approach rooted in international space cooperation. Clearly, these are going to be multilateral, global undertakings. But at the same time, there's a competitive aspect. There's the strategic competition. There's the projection of space power. There are ongoing commons problems and boundary problems and tragedy of commons in outer space with orbital debris, harmful interference issues. How is this competitive aspect going to be addressed is something that fundamentally is of interest and study when we look at the world of astropolitics. Space power, I mentioned it. The projection of space power. The United States has established an independent branch of the military to focus on space power. And the projection of space power is something very, very fundamental. Right now we have a fundamental space power dynamic and a space power competition going on between the United States and China. How is space power going to interplay with our civil and commercial pursuits in the space environment? And what are the projections of space power, and how is that going to affect our capacity for, adhering to the Outer Space Treaty and the peaceful uses of outer space? A number of key questions that arise there. Traditional and non-traditional approaches to space security. Something that's very, very interesting here, just to raise an example, is there's a greater interrelationship and interdependent dynamic emerging between traditional approaches to space security and non-traditional approaches, particularly looking at the interdependence between the military and commercial space sectors. For example, in the United States, 80% of communications bandwidth is for military use comes from telecommunication satellites that exist in private commercial markets, as an example. How is this going to change our approach to space security? I was involved in an interesting study a number of years ago in work with the U.S. Air Force Space, looking at how this brings about some element of deterrence through an approach of entanglement. That if space power assets are entangled with the commercial sector and the private sector, you have then a deterrent capacity that protects both your military space assets as well as your commercial space assets, because they're now entangled in value-added services such as we're seeing in the telecommunications sector. The role of space to address global environmental change and sustainable development. I kind of mentioned this somewhat in discussing emergent and developing space powers. I think that's a fundamental role for them to play. This is a global problem, a commons problem, and space is going to have to play a critical role here, from the remote sensing satellites focused on Earth observations, and looking at not just the use of data that these satellites can gather, but also looking at the development of space-based technologies to support sustainable development goals as established by the world community, United Nations. The debris problem, as I mentioned, that kind of falls out of the commons problem and the boundary problem. How can we ensure the sustainability of space activities? The Secure World Foundation, many of you know of them, has done a lot of great work in this area, focusing on the sustainability of space. I mean, ultimately, we are going to have to better address the congestion problems, the tragedy of the commons problems, to ensure sustainability. And that's rooted in, I think, further advancing and further developing ideas within the commons of space approach and model, and potentially entertaining even common and heritage of mankind models, such as was suggested by the Moon Agreement in international space law. Entrepreneurship and business development, a lot of entrepreneurial activity going on in the space arena. that's something we can further discuss. I know I'm kind of getting short on time here. Another one I wanted to bring up, just to finish up here, I kind of already looked at some of the political, legal, and economic factors in the privatization of space activities, are the management and organizational activities. That's not often discussed much in policy or legal circles. What are the organizational and managerial challenges, particularly in the context of the relationships between the public sector, the governmental sector, and the private sector, the public-private dynamics and relationships, and the organizational and managerial challenges that lie therein within the space enterprise. Political, legal, economic, social factors all affect this, and examining that and understanding those challenges are really, really important. And finally here, thinking about humanity as a spacefaring species, what does, this is more cultural, ethical, philosophical, how we advance in our knowledge. What does it mean to be a spacefaring species? And how do we examine that? For example, NASA, there were 3 missions that successfully got to Mars just in the last couple of weeks. NASA landed another rover on Mars just the other week, Perseverance. And it's conducting science, and it's an outcome of engineering, but it can be studied from the standpoint of human sciences. And what does it mean to be a spacefaring species? What does it mean to explore for life elsewhere? How is this going to affect us as human beings, our cultural, our ethics? What should be the ethics of the space environment? This is largely rooted in issues like of planetary contamination issues. And how do we address those? What does it mean to become a spacefaring species, and what does it mean for us as a human species as we expand outward and as we search for life and search for habitable planets and other solar systems? So a whole range of issues here. I just was able to highlight a few of them, but it kind of gives you a sense of issues of interest that we've highlighted within the project, and we are looking to put forward a publication that's already in the works through Astropolitics, and I'm looking to, in 2022, to begin a book project with, along the lines of these themes, to publish a book on the field of astropolitics.
Good afternoon to all attending the conference. It's a great pleasure for me to be here. And I'd like to first thank the organizer of the conference for giving me the opportunity to do a presentation today, alongside such esteemed colleagues and friends. So the topic of my presentation is the Artemis Accord, which is certainly a topic which has received a great deal of attention, not only in specialized publication, but also in the general press. So the idea of my speech would be to explain why such attention is being devoted to the Accords, and what are the elements that make the Accords so noteworthy of attention. So please go to the next slide. Thank you. And again, keep going. Next slide, please. Next slide, please. Okay, great. So, as a starting point, we can certainly argue without a shadow of a doubt that the Artemis Accord represents one of the most innovative yet controversial developments in the field of space law. Why can we say this? Next slide, please. So in terms of the controversial elements, they can be categorized under 2 groups, those of legal and political nature. We will explore them throughout the presentation, but certainly when you think of legal controversial elements, you can look at the consistency of the Accord provision with international space law, as when you look at the political consideration, you can certainly make reference to the impact that the accords have on international relations among states. So if you take into account the significance and the implication of the elements, of the controversial elements of the accord, we can certainly say that the impact that the accords have go well beyond the limited scope of the accords themselves and go into the more broader realm of space law, space activity as a whole. So next slide, please. So in the next slides, we will first analyze and explain what these Artemis Accords are. Okay, so please, thank you. So the Artemis Accord have to be understood in the context of the Artemis program, which is a US-based initiative, which has been now joined by several countries, that has among its goals the return of humans to the moon by 2024. So the Artemis Accords are intended to be the regulatory instrument that provide the legal foundation, the legal framework that should regulate the activities of states participating in this program. The Artemis Accord have been drafted by the United States, certainly in consultation with other countries, but it's a US document which has been then open to countries willing to join the program, or this Artemis program. And at the moment, 10 countries have signed the accord, including the United States, of course, but also some of the traditional US allies, from the UK to Japan and Canada, and the latest was Brazil. Now, in terms of the legal value of this accord, the accords per se are not a binding instrument, but when a country signs the accord, that amount to a political commitment to comply with the accord's principles. The accord themselves already tell you that on a bilateral basis, this accord will be further implemented by the countries involved. Next slide, please. The accords consist of 13 sections that address different aspects related to celestial bodies activities, from environment, technology, sharing of information, and so on and so forth. And the majority of the principles of the accord are certainly uncontroversial because they mirror established provision of international space law. The problem comes more when the accords address areas which are not specifically regulated by the Outer Space Treaty in particular. And so next slide, please. So now, after this introduction, we can look a little bit more into the detail of the accords. So please, next slide. Okay, great. Well, you need to go one step back. Sorry. Yes, thank you. So when you look at the accords, there are certainly some positive elements to them. I don't want to convey the idea that all is negative, not at all. First of all, when you look at the positive side of the accords, it is important to point out that they promote the rule of law in the context of celestial bodies activities, which means that the state party to this project do not view laws and rules as an obstacle to achieve their goals, also commercial goals, but they see law as an essential precondition to fulfill their goals. And the second important element is that there are several references to the Outer Space Treaty and to the need to comply with the requirements that the treaty imposes upon states, as well as some examples of how you move from the general wording of the treaty to a more practical implication of the treaty provision. Another important element to point out is the fact that the signatory to the accords expressly voiced their commitment to engage with the international community in discussion about the rules applicable to celestial bodies activities. Next slide, please. Now, after the positive sides of the accords, we can look at those who are so at least in my view, more controversial. And as I have anticipated in the introduction, you can look at both elements of legal and political nature. So from the legal perspective, two broad areas can be highlighted. One dealing with the content of the accord, and the second area, the impact of the accord on space lawmaking. The first the first area deals of whether or not the provision of the accord are consistent with the other space treaty, and also relation with other space treaties and the impact on customary law. The second area of interest looks at the procedure that has been used to develop the Artemis Accord and how this procedure may impact lawmaking in the space law field. This is about the legal part. In terms of political consideration, and this also goes back to what Elegant was talking previously, we look at how the accords affect the relation among spacefaring countries and how the accords can be viewed from a certain perspective as an instrument, as a tool of foreign policy. And we can say that basically looking at the reaction that the accords have generated, and then we can certainly try to make some consideration, some reflection on whether or not the accords promote or discourage international cooperation. Okay, this is the introduction of the analysis. So let's start now with the legal analysis, looking at the content of the accords. So please go to the next slide. Thank you. Okay, great. So the first area of interest is the area of utilization of space resources, okay, of celestial bodies resources or moon resources in this context. Because of course, when you're dealing with activities on a celestial body, an essential part of the activity will be inevitably the utilization of the resources contained therein. The Artemis Accords in section number 10 declares that the extraction and the use of resources is consistent with the Outer Space Treaty. As we all know, the Outer Space Treaty does not directly deal with the matter of the utilization of resources. So the answer to the question of whether or not it is legal under the Outer Space Treaty to extract and use resources, particularly for the purpose of making a profit out of it, is left to the individual interpretation. It is clear that the accords embrace the US view of the Outer Space Treaty and the US interpretation on the matter of the use of space resources, as the US have elaborated in domestic legislation. Of course, as you see also in the slide, the acceptability and the legality of the US interpretation is not shared by all. It is controversial. But the most relevant point for us, for our discussion, is whether or not when a country signs the Artemis Accords, then implicitly accepts and endorses the US view on space resource utilization. We can certainly make that case because the accords are very clear on what is their interpretation of the signatory on the matter. So if this premises is true, then we can also argue as a complementary argument that the Artemis Accord are an instrument to start creating a process of creation of elements of custom in relation to the legality of use of space resources under international space law. Of course, it's an open question that we can debate later on. Obviously, we cannot dig deep in all these questions because we don't have the time for that. So please, let's go to the next slide and address another area of controversy of the Accords, which is the next section dealing with deconfliction of activities. This section 11 envisions the establishment of the so-called safety zones on a celestial body surface as a means to avoid harmful interference. Practically, it would mean an area surrounding the operation undertaken by a state, which will be essentially, access to which will be limited in order to prevent interferences with the state activities. According to the Accords, these safety zones will be temporary or limited in size, and this should be respect of one of the principles established under the Outer Space Treaty, which is the free access to all areas of celestial bodies. Well, certainly, I mean, it really depends on how this should be implemented in practice is really early now, but there are certainly questions of whether or not the idea of a safety zone, which is the access to which is limited, is consistent with the Outer Space Treaty. Would that be, would exemplary result in an appropriation of celestial bodies area by other means, which is prohibited by Article 2? How this the free access to the area will be guaranteed? Whether or not will be temporary? One point is clear, that no matter what the signatories to the Artemis Accord do in terms of establishing these zones, those zones are not enforceable against states that are not signatories to the Accord. So how would then you would reconcile interests and rights and activities between signatories and non-signatories remain to be seen. And next slide, please. Another area which is often not really analyzed, but I think is becoming more and more interesting, is the notion of peaceful purpose, how this notion applies to the Artemis Accords. So the idea of peaceful purposes or peaceful utilization of outer space, particularly in the context of celestial bodies, is an established principle of international space law. However, neither the treaties nor UN resolution in the matter ever defines what this means. The problem now comes in light of recent developments at domestic level, where you have the emergence of national doctrines, security doctrines that clearly describe space as a war-fighting domain, foresees conflict in space, and also call for the establishment of dedicated military forces with offensive and defensive space capabilities. So in that context, are we going away from the notion of peaceful use of outer space, or we need to reinterpret it? And how does that apply in the context of the Artemis program activities? What kind of measures would the signatories to the accord take to prevent their interest in the context of the program? Or what would be perceived as a threat? Now, there are so many questions that we need to address. So I think it's an area that deserves some attention. Next slide, please. And the next slide addresses, again, another area which is often not really discussed, which is, please, next, yes, thank you. The relation between the accords with other treaties other than the Outer Space Treaty, and I particularly make reference here to the Moon Agreement. Now, the Moon Agreement is certainly relevant because it's the only space treaty that deals with celestial bodies activities. The point for me is whether or not is it consistent for a country which has signed the Artemis Accord and is also, sorry, for a country which is a party to the Moon Agreement to also sign the Artemis Accord. To me, and I wrote a long paper in an Australian journal about this, the relation is problematic for several reasons. I mean, the Moon Agreement and the Artemis Accord take a completely different approach to the issue of utilization of resources on celestial bodies, with the Moon Agreement embracing common heritage, calling for the need to establish an international regime, while the Artemis Accord are based on a completely different approach. Keep in mind that, of course, again, we don't have the time to elaborate, but the United States has officially rejected the Moon Agreement last year by means of an executive order, and the common heritage of mankind, and the philosophy of the agreement. So if you keep in mind that the Artemis Accord comes from a country that has officially rejected the Moon Agreement, and the philosophy that it embraces, how can a country party to the Moon Agreement sign the Artemis Accord? So the whole thing is confusing and certainly calls for more analysis. At least this is my view. Okay, so this concludes the part on the analysis of the content. So let's look very briefly the next legal consideration, and then we move to the political consideration, and we conclude the presentation. So please, next slide. So the next slide addresses the issue of the procedure that has been used to develop the Artemis Accord and its impact on space lawmaking. So the general problem is, how should rules applicable to an international domain like space be developed? And what is the impact of what states do at an international level? Next slide, please. So what we need to keep in mind is that the basic space law principles from the treaties to resolution, and they're all being developed at international level through a true multilateral process, meaning states sitting together, recognizing the need for rules, and drafting these rules together. A classic top-down approach. In recent years, however, some states have inverted this relation and have started adopting rules, the scope of which is not limited to their domestic jurisdiction, but extend to the international domain of space. And they have done these rules domestically in a unilateral manner. Next slide, please. So from this perspective, how you can categorize the Artemis Accord? Are the Artemis Accord a unilateral initiative or a multilateral initiative? To me, neither of them. Non-unilaterally, because of certainly it started unilaterally, but then it became, a regional limited group approach, but not multilateral because it was not developed as an international initiative by all countries. So it's something in between that I label in my writing as a quasi-multilateral initiative. The relevant point for me is what are the implications of this process and procedure for international space lawmaking. Because of course you are creating a precedent and states feel the need for some rules, they join forces in a limited form, limited group of states, and they pass these rules. How will that affect international negotiation in multilateral fora like COPOS? Would that detrimental to the role of COPOS or not? Well, of course, you're creating a precedent. Another situation where states feel the need for other rules, then rules will be developed outside of COPOS as well. So who knows? So in the end, is this an exclusive approach that is taken by the countries signatory to the Artemis Accord or an inclusive approach? That's again, we can discuss about that. And again, that's, thank you, leads to the final part of the presentation, which is the political implication. Next slide, please. So what is the impact of the Artemis Accord, and can we already see some visible effect of this initiative on the relation among countries? Next slide, please. Let's see. I said in the introduction that the Artemis Accord can be arguably described as an instrument of foreign policy. Why? Because in a way, from the perspective of certain countries, can be viewed as a move to corner them and to force them to react to what the US is doing, particularly looking at China, Russia, and possibly also India. You can see already some visible result of this. There are blocks, sides that are being taken. The US side with its allies and the Russian-Chinese side with their allies. It is the news of a few days ago that China and Russia are going to sign an MOU, probably May or in June, on the establishment on a lunar research base, which then will become open as an international project as well. So again, next slide, please. So at the end of the day, you have to ask the question, do the approach that the Artemis Accord embrace promote or discourage cooperation? It really depends on the point of view. Certainly has the advantage to bring the discussion on the table, but then when you go to the international forum, how you then negotiate? Is it an approach that promotes inclusion or exclusion? And at the end of the day, is it possible to reconcile these two sides that are emerging? That depends on many factors of political, economic nature. So it really depends. Next slide, to conclude my presentation. So the point is that the Artemis Accord is certainly an extremely important development, but certainly controversial. There will be a lot to say, but my hope is certainly that when the era of celestial bodies utilization will start, that will be based on international cooperation and with the guarantee that space will not be turned into an area of conflict. And with this, next slide, I thank you very much for your attention. And if you have any question, of course, you can ask me now in the Q&A, or you can write me with my contact. Thank you.
Great, thank you very much. Thank you, Soumya. Thank you, Professor Bhat. Firstly, can you hear me well? Is all okay? Great.
Yes, we can hear you.
It's a pleasure to be here. It is 5 p.m. in Sydney, Australia, and I can tell you it's a cloudy, rainy day. I hope all is well wherever you are. I know most of the participants are probably in India and Kolkata and elsewhere, but I know Fabio, who I've just been listening to, thank you Fabio, is in China, and so I wish you all well wherever you are. Thank you for inviting me to speak to you. I gather you were Zoom bombed, I understand, so you will be running the slides rather than me. That is unfortunate for you, but I hope all is okay now. I've been asked to talk about the possible, to follow on from Fabio's talk and talk about resource exploitation, also the role of national law, given the theme of this conference, but in a broader context. I do that with a number of hats on. I do that as an international law professor. I do that also. I'm on the advisory board of the Australian Space Agency, although I do not speak for the agency. I'm not employed by it, but I noted the comments that Fabio made about Australia, so I will make some points on that. But I suppose most relevantly for this discussion, I have the honour of having been appointed by COPOS, together with Andrzej Misztal, a wonderful Polish lawyer. The two of us are co-chairing the COPOS consultations on this topic. And so I speak to you also with that hat on, and maybe have some slightly variant views from Fabio on the role of the Artemis Accords and their significance, although no doubt they are significant. But there are many inputs and many initiatives that are going on. And I really want to put everything in context. So I'm sorry, I'm not sure who is organising the slides, but could I ask you just to click, please, to move forward? Thank you, and one more time. And one more time, thank you. Okay, let's put everything in context. We are talking about and this is the way the UN talks about it, the exploration, exploitation and utilization of space resources. This is not a new topic. Indeed, as Fabio quite rightly mentioned, it's already been the subject of one of the international space law treaties, the Moon Agreement, way back in 1979, before perhaps many of you were born. Already in the 1970s, based on the excitement that was generated by an analysis of the moon rock brought back by the Apollo missions, they brought back about 400 kilograms of moon rock and shared it quite broadly with the scientific community. Based on that excitement, there was real anticipation that humankind would return to the moon and exploit it, essentially exploit the resources. Those discussions leading up to the agreement of the Moon Agreement took quite a period of time, and they coincided with other discussions about another area beyond national jurisdiction, that is the deep seabed, i.e. the floor of the ocean underneath the high seas, which, as some of you will be aware, has within the United Nations Convention on Law of the Sea also provisions about exploiting the deep seabed, about mining the deep seabed. And so in this period of the 1970s, there was excitement. International law had to adapt to the ability, one, not only to find and categorize areas beyond national jurisdiction, like outer space, like the high seas and the deep seabed, but secondly, had to adapt to the possibility, given the way that technology had been developed, the possibility of actually utilizing those areas for benefits. Of course, the important thing here is how we categorize those areas. As I said, they're areas beyond national jurisdiction. We had a choice in the way we categorised them, either saying, well, in fact, they're areas, you might call them res nullius areas essentially where nobody had a stake, and therefore there was no framework within which a regulatory rules of the road could be constructed. If you had that, for example, with the high seas and by outer space, if you had no rules, what would happen? We would very quickly have a tragedy of the commons, because people would go to the high seas and dump their nuclear waste or whatever and destroy it. So clearly that model does not work. The other model is the model we've adopted for space. We've adopted it for the high seas. And that is the model where everybody has a stake. We recognise that these areas now, some will call it the global commons. That's not a popular term with others, but if you look at the way the Outer Space Treaty is framed, even though it doesn't use the term global commons, it certainly describes space in the way that we all have a stake in it. There are common benefits to be derived for all countries out of the exploration and use of space for peaceful purposes. So the discussion, therefore, gets to this point. We all have a stake in areas. We understand that by exploiting the resources in the areas, there are benefits to be gained. But here's the difficulty. Only very few countries actually have the capability to undertake those activities of exploitation. And you must remember, if you could just press again, please, the geopolitical context of where we were. We were in a period in the 1970s when all of a sudden many countries were emerging with independence. The 1970s, we had 40 new countries emerging. All of those countries had been former colonies. And to a larger or lesser degree, colonies had been, the resources of colonies had been exploited by their colonial masters. And so when former colonies become independent, they become fiercely independent. And then if you say to them, here is an area, you all have a stake in it, whether you're a large country, whether you're a newly emerging country, we all have a stake in it. That's the way we categorize it at law. International law applies. There are benefits to be derived from utilizing these areas. But then you say only one or two or three people, three countries, are actually capable of deriving those benefits. That gives rise to a massive geopolitical fissure. What do you do? How do you share these benefits? What is the legal characterization of these areas? And so, as you know, in the Law of the Sea Treaty and in the Moon Agreement, we came to compromises of a political nature, which categorizes, in the case of the Moon Agreement, the celestial bodies and their resources as the common heritage of humankind. Likewise, the deep seabed and the resources of the common heritage of humankind. And in those two treaties, the exploitation is permissible under certain conditions in terms of safety and sustainability, etc., but also with a benefit sharing provision. And so out of that, when that was included in those two treaties, the industrialized countries who had agreed to the recognition of space and the high seas in this way, the industrialized countries said, well, we just don't agree. We're not going to be part of that system. And so it took a long time to get the industrialized countries into the Law of the Sea Treaty, 12 years later. And that was by, in a sense, a sleight of hand at international law, which we won't go into. But they haven't come to the Moon Agreement. So this area gives rise to a range of, and I heard Eligar before, a range of very intense geopolitical issues as well. Next click, please. But it's not insurmountable. We've had similar discussions about other resources of space, and here I'm talking about the geostationary orbit. You're all aware of what the geostationary orbit is. You're all aware how incredibly important the geostationary orbit is. And you're all aware that there was, again, the capacity of only 1 or 2 or 3 countries in the early days to actually go to geo and to actually be able to garner the benefits. And yet all of the other countries were saying, wait a minute, we have a stake. There must be a way in which the utilization of that natural resource can some way be divined in a way that suits us all. And ultimately, and it did take years, but ultimately we've come to a government structure for GEO through the International Telecommunication Union. Now, of course, we all understand it's not perfect. However, it does allow for equitable access for all countries to GEO, and it does minimize the first come first serve idea, although as many of you will know that's part of the structure still. But largely we had a problem of natural resources, different capabilities, and we were able to define ultimately a multilateral governance structure. And so I believe that we can do that also for resources in an appropriate way. Next clip, please. And again, thank you. So, and again, thank you. I won't talk about the Outer Space Treaty and the Moon Agreement. Fabio's done a very good job of outlining, but clearly, from an international law perspective, those 2 treaties are very relevant. There are other treaties that may also be relevant in terms of this question. Next clip, please. And as you're aware, and again, thank you. As you're aware also, and again, the notion of how we regulate space is also by way of this concept of soft law. Now, I hate that expression, soft law. If you've heard me speak before, you will understand why I hate it, but it's an expression that we all use. And within the soft law regime, which has legal value, it's not traditionally binding in the sense that we understand treaty law, but it certainly has value. We have various guidelines. The 2 in front of you there, the long-term sustainability guidelines, very important, agreed by COPOS in 2019, and before that the debris mitigation guidelines are also relevant to this topic. Next clip, please. So, and again, what I want to do is go through what conversations are going on. And again, thank you. And one more time. And one more time. Thank you. So, firstly, as Fabio said, and as I pre-mentioned at the beginning of my talk, this is an issue that's now at the forefront of discussions within the United Nations system, particularly through COPOS and particularly through the legal subcommittee of COPOS. It's been a single agenda item, which is a way that you have it on the agenda of COPOS since 2016. And as I said, in 2019, COPOS decided as a precursor to establishing a working group on this topic. That's the intention, to have what are called scheduled informal discussions on this topic. And as I mentioned, I had the honor of, along with Andre Michtal, of being the chair of those discussions. They were to take place already in 2020. For COVID-related reasons have been postponed, but we're going through a whole range of conversations with every country of COPOS, and there are 96 member states, and we will have these informal discussions at Legal Subcommittee in June of this year. And the idea is to have an open, transparent, and inclusive discussion to work out the way forward, how we determine what rules of the road are appropriate, and even, although it may not be in the initial discussions, what the substance of those rules may be, although that is something that will continue on. These discussions are the pinnacle of the multilateral process, and to be honest, in the really big issues about space, and this is a really big issue about space, we need to understand that, could you change the slides back to the way they were, please, because the people can't read the slides. The really big issues require a buy-in from all stakeholders, all of the major spacefaring nations, but not just them, all of the countries, because, and I've been privileged to be involved in these discussions for a long time on a range of other issues, you cannot have a purported system of rules of the road for the really big issues where there isn't buy-in from the broad sector of the international community. I'm not sure, thank you so much if you can do that. Yes, click forward. My apologies, I would have controlled this, but obviously I can't. Yes, if you can click again through this section. Thank you, keep going. And again, and one more. Thank you. So the next level of discussions, and this is relevant, of course, to the overall theme of your conference, is what is happening at the national level, and also, because of Artemis, the bilateral level, and the, if I may say, the mini-lateral level, as opposed to the multilateral level. So we've got the national legislation of the United States in 2015, Luxembourg 2017, UAE very recently. We've got the Artemis principles in the executive order in April of last year. They came about because our scheduled informal discussions were postponed, and so the Americans put forward their Artemis principles at that time with the executive order to keep a momentum going forward. We've then in October had the Artemis Accords and that have been described by Fabio, but the Americans and all of those countries that have signed on to Artemis are not the only players in this game. We understand, we know the capabilities of China. We understand, we know the capabilities of India and the ambitions of India. We know the ambitions of Russia. Turkey has announced it wants to go to the moon. Israel has announced it wants to go to the moon, and in fact had a hard landing on the moon recently. And so there are many initiatives. Obviously, ESA and the European Union and the European countries are doing a lot of work as well. And so many of these initiatives, these discussions are going on, and they're giving rise to really interesting ideas, like some of the really interesting ideas in Artemis, like some of the really interesting ideas that have come out of other national initiatives and programs. And then the third level of conversations are, and if you could just click to the end of the slide, please, the work being done through civil society. All of you are involved in a range of webinars. There are so many space webinars. If you could click please. A range of webinars that involve civil society down to the bottom of the slide. Thank you. So you've got the Hague Working Group, which has done its building blocks. You've got work by the Moon Village Association. You've got work by a whole range of civil society conversations also on this point. If you could click down, please, to the bottom of the slide. Thank you. All the way. Keep going. Keep going, please. And one more. Thank you. So you can see on the slide here, there are a range of different conversations. So next slide, please. And this is my last slide. Where do we go from here? What is the future? The future will involve a continuation of these discussions. It will clearly involve and actually culminate in the multilateral process. Through COPOS, even the Artemis Accords recognize the importance of the COPOS discussions. But the other conversations will go on. And it's good that we have those conversations because they will feed important input to the multilateral discussion. So please click forward. And again. And again. So we'll see a continuation of bilateral and minilateral arrangements. We'll see other countries perhaps signing on to Artemis. We may see other instruments emerging. We may see more national legislation of the like of the UAE and the United States and Luxembourg in terms of specifically addressing. I think the more of these initiatives that are developed, the more we will see important ideas that ultimately will feed as inputs to the multilateral. And it's where the multilateral process takes place through COPOS, through firstly the discussions that I have the honour of chairing, but then ultimately through a working group and whatever. Ultimately, all of these inputs, some of the initiatives from Artemis, some of the initiatives even from national legislation, may be taken up by the broader community of countries, ultimately to give us an agreed framework for the rules of the road. That agreed framework will not be a copy-paste of Artemis. It will not be a copy-paste of any, but it will certainly take into account and maybe incorporate some of those things. It may even incorporate some initiatives from the Moon Agreement itself, although we understand that the Moon Agreement is not widely ratified and certainly has, as Fabio said, been rejected by some countries, but it still has some interesting ideas in there. And my role and the role of my co-chair is to encourage all these inputs. So I see Artemis as a really important input. It's brought forward a number of reinforcements of the Outer Space Treaty, but it's also added some additional things that give rise to, as Fabio says, legal questions and political questions, but they will feed into the broader discussions. And these broader discussions have many issues that need to be taken into account. If you could click again, please. And just to the bottom of the slide, please. Keep going, thank you. And again, and again, and again. Thank you. So, what are the issues that will be involved? And of course, national legislation is one of those inputs as well. Obviously, there are legal issues. Obviously, there'll be governance issues. Obviously, there'll be issues around sustainability. And Artemis talks about trying to do things sustainably. The Moon Agreement talks about it. Other inputs. And of course, we have the sustainability guidelines. Probably the most important thing, and Fabio made mention of this, and I know that Eligar did in his talk as well, is the overarching requirement to avoid conflict. One of the main reasons we have a non-appropriation principle in international space law, it's probably the most important principle amongst many important principles, is that it's a conflict avoidance measure. Because we've seen on Earth that often conflicts stem from a quest for resources, stem from a quest to, if you like, appropriate areas because of their resource value. If we are not careful, if we do not conclude an overall rules of the road where all of those with capability plus all the other stakeholders agree, more or less, by consensus of what those rules are, then we have a real danger of going against that absolute rationale and raison d'etre of why we have non-appropriation, to avoid conflict. As Fabio said, one of the initiatives in the Artemis Accords is safety zones, and it's under this heading of a word that is not a very nice word, but deconfliction. Now, you may or may not think that the notion of safety zones and avoiding harmful interference, is important. Of course it's important. But as Fabio said, one, the Artemis Accords, as between the signatories, is not legally binding, although clearly they are politically bound to it. But clearly, those that are not involved in Artemis, given that safety zones is not something that international space law talks about, indeed, as Fabio said, it may actually be contrary, in one sense, to some of those important principles of international space law, whilst promoting some others. So it may be promoting avoiding of harmful interference, but be contrary to freedom of access. International law always has conflict. We have to avoid them. But clearly the safety zones as expressed in Artemis are not going to be binding on other countries. And so we just have to be careful. Also, safety zones don't work from a practical level. If you talk to miners, like terrestrial miners on Earth, and you talk about safety zones, they say, well, we're not interested in that. We want exclusivity, exclusive zones to undertake our mining activities. And so when you start talking about exclusivity in an area, then again, you really are challenging some areas, particularly if that notion of safety zones is not binding on others. So we have to avoid conflict. We have to take into account all of the technological challenges, and there are many, because if we get that wrong, we endanger perhaps human life, but we certainly endanger the environment. We have to recognize the science of space. Space is just not something to be exploited. And above all, and perhaps this last bullet point is even more important than everything else, there are so many other aspects to space, and those other voices are equally important in this discussion about exploitation, exploration, and utilization of natural resources. There are cultural issues. There are humanistic issues about space. Indeed, the future of humanity is inextricably tied to the way we view space, the way we respect space, the way we maintain space in a sustainable way for future generations. We are stewards of the planet, we are stewards of space. All of those issues under those 4 or 5 bullet points all come into the mix as further inputs in the broader discussion about what the rules of the road are. And so my point here is it's important to have these discussions. It's important to have all of the conversations and more. It's important, if you are passionate about this area, for you to get involved in discussions with NGOs, other parts of civil society, with your government, etc. All of those inputs are important, but ultimately on this issue and other big issues like space debris and how we're going to ultimately deal with huge constellations of satellites, those really big issues will require a multilateral process, giving rise to a multilateral consensus in whatever form on the rules of the road. Let me just make one point about Australia. It's not on my slides, but as an Australian, I need to just respond to Fabio. So Fabio's point is he doesn't believe it's possible for a country to be a party to the Moon Agreement and also to be a signatory to the Artemis Accords. Now, I have my own personal views. I won't express them, but I do know that, as you know, Australia has in fact done that. It is a party to the Moon Agreement. It's also a signatory to Artemis. So from the Australian government's perspective, and I do not speak for the government, I'm not a government person, the Australian government has taken the view that those two documents are not inconsistent. And I can inform you that the Australian government has told me that they will be making public their interpretation of the Moon Agreement, and clearly one would expect saying that there's nothing in the Moon Agreement that means that they can't be a party, a signatory to Artemis. Clearly they will say that. They will be making public their interpretation probably at legal subcommittee itself in a exchange of views by the countries. So we shall wait and see. I have personal views. I won't share them with you because it's really not important what I think. But as Fabio says, there are many issues that come out of Artemis. There are many issues that come out of the Moon Agreement. There are many issues that come out of all of the conversations and all of the ambitions of all of the countries. They are important. We will see them in the multilateral process. Thank you for your attention. I hope I haven't gone too far over time. I know we started late. And I really thank the organisers again for giving me the opportunity, and I wish you all well in this conference. Thank you so much.
Thank you so much.
So thank you very much indeed for the kind introduction and in particular for the invitation. Congratulations, I should also say, for hosting this very interesting and exciting event. I should say that I'm always impressed by Indian tradition in space law teaching, but also space law diplomacy. And in my capacity as president of IISL, I'm very pleased about the huge participation and enthusiasm of Indian universities participating in the Manfred Lux Space Law Moot Court organized by IISL. And it is my particular pleasure to inform you that the competition in 2020, which was unfortunately, of course, held virtually only, was won by an Indian university from Delhi. The competition was, as usual, judged by 3 judges from the International Court of Justice, and your team prevailed and was announced as the winner. And I would say that this is a big honor, and it also shows the quality, the highest quality of teaching, academic teaching in space law in India. And this, of course, extends then to diplomacy. And India always played and still is playing an enormous role in fora like the United Nations Committee on the Peaceful Uses of Outer Space, its legal subcommittee, which I had the honor to chair between 2014 and 2016. And I must say, India always played a really important role in the deliberations of the legal subcommittee. And this does not come by chance, but it comes because you have such an excellent foundation of excellent scholars, students, and also then diplomats in that field. So with that, I would like to turn to my short presentation. I would like to give you a few glimpses on contexts, new contexts for space legislation. I will not give you a long and detailed and scholarly description of national space legislation, but just want to provide you with some glimpses of what is of particular relevance and what is also of international and global relevance when it comes to national space legislation. Could you put on the next slide, please? As we look at the challenges of today to international space law, we should never forget that one of the key principles is that we have to maintain peaceful uses of outer space. This is something which is important, of highest importance even, and we should never forget that this is one of the most basic principles. We then have to also provide, and this is something which emerged during the past decades and is now taking more and more speed all over the world, we have to provide a sound regulatory framework for commercial and in particular private uses of outer space, and private uses of outer space are in the core of being governed by national space legislation. We also should, and I always, really always stress that in presentations, we always have to keep in mind that we have to maintain the principle of space as a province of all mankind. And this is not just an abstract principle, it also has clear, very clear and precise repercussions on how we want to organize space activities, also on an international level. And it also has an impact on the way we look at, for example, space mining and the question of appropriation of resources in outer space. So the province of all mankind is a principle which has big, big relevance. Dealing with a growing amount of space debris and operations in near-Earth outer space is also getting more and more important, in particular in view of the mega constellations. And we also have to see that it is a challenge, but we have to tackle the challenge to guarantee the coherence of space law development on the international level, So we have space lawmaking in UN Corpus, but we also have space lawmaking in ITU. And we have to guarantee the coherence of space law development on the national level. And here we are with our issue of today, the national space legislation. What I would like you to recall and remember is that harmonized national space legislation and regulation is of great importance for the further development of space and the utilization of outer space. Next chart, please. On this chart, I put down 3 areas where you will find how important new contexts for national space legislation are. Some of them do not easily come to our mind when we just say national space legislation shall serve to implement Article 6 of the Outer Space Treaty, to authorize and supervise the activities of private actors, but it is broader, the question of national space legislation, broader for the international context, and these 3 points are, to my understanding, of particular relevance. So, first, national space legislation is important and relevant for the global space economy. We are seeing that there is a growing global space economy. Some studies say that this global space economy currently covers around $400 billion per year, and it might raise to $1 trillion by 2040. So, national space legislation can prevent to provide a global level playing field. And this is what everybody should be interested in, that the harmonized development of national space legislation does not allow for distortions and for unfair competition. And that means that a global level playing field will also rest on a harmonized development of national space legislation. We do not want flags of convenience, like we know it from maritime traffic, in outer space. And therefore, it is really required to have this global level playing field through a harmonized development of space legislation on the national level. Second point. When we look at one of the key challenges of international space law, this is the development of a space traffic management regime. And national space legislation also plays a very important role because a lot of the provisions for a globalized space traffic management regime will rest on or be implemented by national space legislation. So there is also a need, in order to maintain coherence and also level playing field in this area, to have a harmonized global development of national space legislation. Last point I would like to mention, and there we enter again into a different adjacent field of activity, and this is that national space legislation has a big impact on space security and cyber security. And the question is, how can national space legislation support space security and cyber security in the use of outer space? And how can we avoid that through national space legislation there is conflict or potentially conflict being created, and the lack of security or cyber security can be prevented. So these are 3 questions and 3 areas I wanted to point out to you, because typically these elements are not touched when we talk about national space legislation, but they should also provide you with an inspiration of how far-reaching space legislation on the national level can impact on the international level. Last chart, please. On this last chart, I just put down 3 points where potentially the future of space law lies. Principles which are already existing, but which we have to keep in our minds when we talk about space law, when we teach space law, and when we practice space law. And this is that the future of space law certainly is dependent and relies on providing transparency and confidence building in outer space. So an international policy for outer space has to take up the issues of transparency and confidence building, because otherwise we will not be able to implement international space law. The second point is that we will focus more and more on regulating the behavior in outer space. So the traditional space law talks about the status of outer space and the status of the actors in outer space. But now and in the future, the focus of space law development will lie on behavior in outer space, and we have already started with the long-term sustainability initiative, and we will continue this with space traffic management. And then the last point, and this is also where India always showed a very clear stand in the international fora. It is that we have to provide a fair and reasonable regulatory framework for the global space economy and space activities, and fairness and reasonableness is something which can go together, and we have to simply find the right balances, the right ways that we can prevent and avoid something like the first come, first served, but to have also for the latecomers and the future generations the opportunities and possibilities to conduct space activities. But there is only one fundamental principle for us as space lawyers, and I'm sure all of you will join in this statement and in this principle. It's also the main mission statement of the International Institute of Space Law. And this is that we all have to work on maintaining the rule of law in outer space. So thank you very much for your attention. Thank you for inviting me.
Thank you very much. Thanks a lot. My talk may again be a very short one, because I just want to highlight 3 major issues which are for just to excite the basic brains. My idea is not to go in a long, elaborate presentation, but only to give certain major issues which should be considered as the points to ponder. Right, to begin with, we started with space activities more as a breach of the frontier of outer space, and these were primarily, can you hear me all? Can you hear me?
Yes, Professor, you're audible.
All right, thank you very much. So initially, our earlier space activities were more exploratory. They were purely for exploration of the outer space, and perhaps partly for aggrandizement of the nations. The next era of space activities related to the uses of outer space, which primarily meant communications, broadcasting, television, navigation, remote sensing, and so on. This was the area where we made use of outer space. Then we came on to commercialization, where we made a better use of celestial bodies. We haven't yet made much use, though we have brought a couple of samples and they have shown a lot of promise of certain precious minerals which can be extracted or taken from the surface. Now these CBs or the celestial bodies offer a lot of scope for excavation and bringing raw ores or for processed material or processed minerals. Now, initially, all these activities in space were managed and executed through governmental space agencies. But now, as commercialization is coming up, this particular aspect is losing its ground. The governments are no longer willing to invest in commercial space activities. And hence, there is need, because of withdrawal of the state government, either through budgets or through activities, and the void or a gap is being created. In fact, one example of this could be that even the US quarters and the ISS, International Space Station, are now being let out on lease for commercial purposes. Now what happens is, if the governments withdraw their money or the budgetary allocations, private enterprise in the meanwhile has developed to fill this void. And what happened was that the private business captains they envisaged a lot of potential and profitable business opportunities in the outer space. But it required a lot of funds, which they have managed. Big tycoons, big companies, SpaceX, Virgin Galactic and others have the money. And then it was that after all, space activities are highly technology intensive. With that being, they have harnessed, they have obtained, and they have put them in place by management so that they can undertake today or initiate today space activities. Perhaps if I were to say Virgin Galactic and SpaceX are almost ready for low Earth orbits, which will be an experience. Now, if at all, as we said, that privatization is going to happen, and not only happen, is almost on our door, then what are the implications of privatization in space activities? I would just mention a few. The first is that the business vision is different altogether. Business vision is not congruous with what we call as the state public policy. Both are different. Another reason is that the prime motivation of business is profit. And for that purpose, they indulge in competition. Now, this is not what is really wanted in space. In space, what you need is not competition. In space, what you need is cooperation. It's a domain where cooperation is more important than even coexistence, which we have under the international law. A third reason is that the business has a tendency normally for cost reduction and becomes at times unethical also. And this may undermine safety of space operations. And it needs to be appreciated and remembered that space is unsparing. It normally or mostly does not give a second opportunity. It could even be otherwise. Why I say that the business has a tendency to economize and cut corners, and sometimes do not follow the best recommended practices. Perhaps one example of that which I could give was the Tesla car which was sent in a SpaceX rocket was sent unsanitized. So it is believed that it was sent unsanitized for space purposes. Of course, there are certain advantages also with privatization, but we need to have a proper control and harmonization. If at all we accept that privatization has come to stay, let's quickly enumerate some of the challenges which it will have to face. Privatization will first face technological challenges. It's not so simple to say that yes, they can send a rocket, but it needs a lot more than that. I also agree that private enterprise has been sending rockets either to convey the cargo to the ISS, but other activities of space travel, space tourism, excavation of raw materials, minerals would need a lot more than simple transportation. Again, another challenge which comes up is legal. Outer Space Treaty does not permit sovereignty or appropriation of outer space resources. This has been said by many speakers earlier. I'm only reiterating it. Now, if that be so, under what reasons shall we be able to do it? And if we do it, will we do it in the best interest of all countries? And if we really want to do it also, do we have the modality to serve the best interest of all countries? We need it, and we'll discuss it later. The next challenge which privatization has is ethical. Business is not always ethical, and business is not always legal also. Businessman knows where to cut corners with law, and he also knows where to cut corners with ethics. So these are the compromises which very often are made by business, but would not be desirable in the outer space activities. Another point which I want to raise is, generally, outer space remains as an ungoverned domain. I repeat it. Outer space remains as an ungoverned domain. We have a law, but law does not mean governance. It only means the states to behave in that manner. But governance is something more than that. And this is where we need a proper management of outer space environment and proper governance of outer space. I'll come to the solutions later, but let me highlight the challenges at this stage. So, if we need to govern outer space, we need some sort of an organization or an institutional setup. I'll discuss that a little later also. Now, before I discuss the solutions, let me dwell a little on the need for national legislation, which has been the theme of this particular conference. National legislation for each country would differ according to its own needs and according to its own constitution. And perhaps, as Shrogl said, according to the ambitions of the people also. What exactly are we looking for? And that is what will really give us, something which is a worthwhile national legislation. Now, what are the salient considerations which you need from a legislation? What should it have? A national legislation should be consistent and enduring. It must contain and should have, because the Outer Space Treaty puts a responsibility on the state for continuing supervision, and that must include what we can call mandatory technical inspections of spaceworthiness of space objects which are launched by the private enterprise. Now, coming to legislation again, as a general principle, my recommendation would be to make it very sketchy and skeletal. It should not be very detailed. There are some countries who have a very long and detailed space law. My preference would be to have short legislation which talks in terms of principles and requirements, basics, and thereunder the rules should be drafted and framed by the government. That will provide flexibility. That will give the power of change. Otherwise, laws are very sluggish and they are very difficult to change. So it would be in our interest to have short national legislation which gives you what exactly you need and gives you the flexibility and authority to create rules under that to suit the exigencies and for the coming contingencies in the space domain and in the space activities. Now, coming to the last point, we have talked of national legislation as one solution, or at least one rider on the privatization. But that's purely from the domestic level. Privatization, when it goes to space, it will have an international level also. And my suggestion would be that we certainly need an international regulatory authority. If I were to venture out and make a suggestion, my suggestion would be, why can't we resuscitate Trusteeship Council, which is lying defunct now with the United Nations. Let the Trusteeship Council take over its original role of governance, and we need governance in outer space. And the Trusteeship Council could now take over the trusteeship as the common heritage of mankind. And that's where I think we need some sort of a regulatory authority and institution. Second point is, Outer Space Treaty has lived very well, has been excellent drafting, has had the vision, but unfortunately its vision was not so long, not so far away as to really could have predicted what has come in just in the last 5 centuries. Today, commercialization of outer space and commercialization of celestial bodies is just round the corner. It needs not only just an organization, it needs law also. And that particular law, I think we can get through our small, call it as a specialist law. And that specialist law could be a specialist treaty. Outer Space Treaty talks in concepts, province of mankind, no sovereignty, weapons of mass destruction. These are very good concepts evaluated at that time. But today, times have changed. We have reached the stage, or we have reached the age of assets. There is time we have a specialist and specific, either a protocol attached to the OST or have a separate special treaty which can help us to develop a very sound, harmonious and useful outer space domain. Thank you very much.
Yes, thank you very much for that kind introduction. Are you able to hear me?
Yes, Professor, you're perfectly audible.
Okay, excellent. And thank you for putting up my presentation already. I appreciate that. I'd like to begin, first of all, by thanking Professor Bhat and the West Bengal National University of Juridical Sciences for inviting me to participate in this conference. I'm certainly humbled by the company in which I share this platform today, and I hope that I can make some contribution towards providing the attendees of the conference with some, well, I suppose, insight into national space laws from both a practical and a conceptual perspective. I know that for most of today, we have already heard quite a bit from other speakers, far more qualified and experienced than I am, about different aspects of national space laws and how they are enacted and how they apply. What I want to focus on with my presentation is one particular issue, which is the adequacy of these national space laws in dealing with international liability arising from activities that do not relate to launch. We have heard in the context of the space legislation how most of the laws deal with the regulation of launch activities. They focus on the concept of launching space, and they focus on the liability that arises under the Outer Space Treaty for damage caused by space objects. And by way of background, it's apparent, I think, to all of us that the three predominant objects of these national space laws are threefold. The first is to regulate private space activities. As Professor Shrogl and others have mentioned, the obligation of the appropriate state to authorize and continually supervise private space activities is specifically prescribed under Article 6 of the Outer Space Treaty. Secondly, especially for states that are members of the Registration Convention, and even if they're not, they may voluntarily do so under General Assembly Resolution 1428B in relation to the registration of space objects. And thirdly, and this is the one I wish to focus on first and foremost, is the ability of the state to pass on any international liability of the state for private space activities to the private persons or entities that are responsible. Next slide, please, sorry. Sorry, please keep going. That was the highlighting the point that I was going to make. Thank you. So, as can be seen if one were to look specifically at the scope of the application of national space laws, those that have been enacted so far, there are quite a few states that are focused primarily on their liability for damage caused by physical impact by or between space objects. And that liability is specifically prescribed in Article 7 of the Outer Space Treaty, and also the Liability Convention, both generally and specifically under Articles 2 and 3.
As I will illustrate by way of example, some of these states have legislated to focus only on licensing space activities for which they are the launching state, or they have legislated to only regulate launch or returns or other related liability for the purposes of the liability convention. At the risk of repeating others, the launching state definition under Article 1 of the Liability Convention talks about a state that launches or procures the launch of a space object, and a state that from whose territory or facility a space object is launched. As is evident from the definition, as well as the other provisions of the Liability Convention, more than one state can be a launching state. And also, very importantly, more than 4 states can be launching states. Especially in such a globalized industry as is the space sector, there is a particular likelihood that satellite operators, or even for that matter, launch operators, may be multinationals that do not necessarily attribute themselves to only one state. So it is possible for multiple states to act jointly in any of those 4 limbs of the definition of a launching state under Article 1 of the Liability Convention. And a lot of the national space laws attempt to capture that by applying the scope of that national space law to, yes, please proceed, yep, to the activities that occur within their territory and activities that are conducted by their nationals anywhere, in order to capture all 4 limbs of the definition of a launching state. It's important, however, to also note that Article 6 of the Outer Space Treaty is also a liability provision. Article 6 of the Outer Space Treaty says that states bear international responsibility for national space activities and to authorize and continually supervise the space activities of non-state actors. The provisions of Article 6 needs to be considered against the background of the customary principles of international law applicable to state responsibility. In particular, the International Court of Justice cases on Corfu Channel and Nicaragua. From those cases and from customary principles that have been restated previously, we know that state responsibility, as in liability, arises when an act, public or private, can be attributed to the state. And if one thinks about Article 6 of the Outer Space Treaty in that context, well, let's focus on those 2 limbs there. If they are national space activities, and let's assume for the moment that national space activities means activities conducted on behalf of the state, then clearly they are attributable to the state, therefore the state is responsible. By the second limb, if the state has to authorize and continually supervise a private space activity, they have knowledge on that space activity, then from the principles that we know from Corfu Channel, if there is an international act that is capable of causing transboundary harm, of which the state is aware and does nothing to prevent it, or for that matter actually regulates it, then it is attributable to the state. That, of course, is a 2-minute summary of a very complex area of public international law. But in broad strokes, the Article 6 of the Outer Space Treaty, it is also a liability convention, no less so than Article 7, and if anything broader than Article 7. And it imposes liability for both national and private space activities alike. The better way, therefore, to look at Article 6 and Article 7 is that Article 6 lays down the foundation for international responsibility and liability for space activities generally, and Article 7 and the Liability Convention focuses specifically on physical damage caused by space objects or collisions. So the first take-home point from that slide is states are responsible, i.e. liable for space activities that are attributable to them. The If we could go forward 2 slides, please. Thank you. In addition to the complications arising from Article 6, there are also circumstances where a state or their nationals may conduct space activities without the state being a launching state. For example, if a state or private entity of that state starts controlling third-party spacecraft or operates third-party spacecraft, and when I say third-party, I mean a foreign spacecraft, if they purchase a foreign spacecraft that is already in orbit, if they acquire territory or as a result of state succession become internationally responsible for the purposes of Article 6 for the space activities of entities or a state that no longer exists, and therefore would not have been a launching state for the purposes of Article 1 of the Liability Convention, and also international business may restructure, with the result that a state that was not involved directly with a launch for the purposes of the launching state definition may nevertheless be carrying out space activities for the purposes of Article 6. So the important point to note, therefore, from this slide is states may very well be liable for space objects for which they are not the launching states. A good example of, for example, the acquisition of territory is in 1997, when sovereignty and jurisdiction over Hong Kong was returned from the United Kingdom to the People's Republic of China. At that point, satellite operators that are based in Hong Kong, registered in Hong Kong, may have led to the United Kingdom being a launching state of particular space objects, but from the point of the handover, the operation and control of those satellites are being conducted by private entities for all intents and purposes of China, in circumstances where China was never a launching state. So in those circumstances, if the national space law is directed only at Article 7 liability or launch liability, then it would not capture international liability arising from Article 6, and therefore not be able to pass on that liability if they choose to do so to private entities. I hope you're with me so far. Now we're going to look at the national space laws and see how they actually fit into this spectrum or this problem. As we have explored throughout today, national space laws tend to vary in scope. For the purposes of looking at how Article 6 interacts with these national space laws, we can neatly divide these national space laws into 4 categories. The first are national space laws that deal with all kinds of space activities. Doesn't matter if it is launching, doesn't matter if it's operating a space object, doesn't matter if it is a mining an asteroid, any activity in space is captured by that national space law. The second category is space laws that only deal with launches or deal with activities relating to that state being a launching state. The third is you may have legislation that deals specifically with a non-launch activity, such as remote sensing or asteroid mining or resource utilization. The fourth category is where you have laws that are couched in general terms as if they are meant to cover all kinds of space activities, but there are specific provisions of the law that would only operate when it comes to launch or launch-related activities. So how do the national space laws that we are aware of fall into these 4 categories? Let's have a look at the first category, where we have legislation that deals with all space activities. And next slide, please. And I intend to run through these a bit quickly because they are just examples. In the case of, for example, Austria, Belgium, Kazakhstan, South Africa, and Sweden, ranging in time frame from, sorry, I'm not done with that slide yet. Please go back. Thank you. Ranging from Sweden, which was enacted in the 1982, to laws, for example, in Austria and Kazakhstan, which was just in the recent decade. they have enacted legislation that requires licensing and regulation for all space activities. Not just launch-related activities, but any kind of activities to do with outer space. And in that way, they capture not only liability or responsibility under Article 7, but also liability and responsibility under Article 6. Next slide, please. Then we have a selection of countries, and as you can see, a significant number of spacefaring states that have legislated or enacted national space laws that deal really only with launch and launch-related liability. My home country, Australia, is one of those examples where it deals specifically with licensing of launch activities, ranging to, as you can see, Korea, Brazil, Hong Kong, Norway, Ukraine, United States. I know Hong Kong is not a country, but Hong Kong is my birthplace, so I hope you will allow me some indulgence of treating the Hong Kong space law as if it is a national space law when Hong Kong clearly is not a nation state. These legislations would capture liability under Article 7, would capture international duties and obligations under Article 7 as well as the Liability Convention, but of course would not deal or adequately deal with issues and liability or responsibility arising from Article 6. Next slide, please. Now, this third category is perhaps the second smallest category of national space laws. They're space laws that regulate particular activities or particular circumstances. The first laws and regulations of Brazil, for example, deal specifically with particular spaceports rather than over Brazil generally. Canada's national space law deal only with remote sensing. And Luxembourg and the United States have both legislated dealing with resource utilization. Of course, just because they have enacted specific laws dealing with a specific activity doesn't mean that they can't or don't legislate on space activities more generally. For example, the United States have certainly done that, and of course, Professor Hoffman, I know, will be speaking on the new Luxembourg space law, which is, of course, wider in scope than just resource utilization. Next slide, please. The fourth and the last category is perhaps the trickiest one, because they are laws that, on appearance, apply to all kinds of space activities, and therefore would seem to capture both Article 6 issues as well as Article 7 issues, but in practical terms, they do not. For example, the Dutch law deals with space activities generally, but when it comes to the specific provision dealing with liability, it only passes on liability that arises under Article 7 to private operators, and it specifically refers to Article 7, which means it will only deal with liability and responsibility that arises from launch activities, because it only deals with damage or liability arising from impact by space objects. The Russian law takes this to an even more specific level. It says that there will be full compensation by the state to foreign third parties that suffer damage in the case of direct damage caused by spacecraft accidents. So if it is not the result of direct damage, for which Article 7 would apply or the Liability Convention would apply, then there is no full state compensation under the Russian law. So even though the Russian law is very wide in scope when it comes to space activities, the actual provisions itself when it comes to passing on liability or indemnifying space activities are much narrower in scope. So they are deceptively wide, but in practical terms, not so much. Next slide, please. There are also some practical issues that arise as a result of these laws falling into these four different categories. Because the varying licensing and regulatory burden means that private operators may be encouraged to do some foreign shopping. They may choose a licensing forum that doesn't actually regulate what they're trying to do or imposes a lighter burden than what they're trying to do. A good example for that in about a decade and 2 decades ago now is the example of Sea Launch, where they sought to pick and choose where they would base themselves so that they would be able to choose the relevant national space law that would apply to them. And more specifically, to avoid the application of the American law, for which they were unsuccessful because the US Congress then changed the law to make sure it applies to them. There's also a need in a practical term to deal with issues that are of commercial reality. For example, issues such as the International Traffic in Arms Regulations, or ITAR, the Missile Technology Control Regime, or MTCR, or other mixed arms control issues may prevent compliance with regulatory obligations. If the technology cannot be passed on to, say, for example, a state regulator, then there would be a difficulty for a state regulator to be able to certify a private operator as complying with the law if they can't have access to the technology to be able to make that determination. Secondly, the law also has to take into account the actual commercial availability of insurance coverage. If you have a law that says, for example, that you must take out in-orbit insurance for a space object, but in-orbit space objects are notoriously hard to get because the market simply isn't there, then it would make it impossible for a private entity to actually comply with that regulation. And both of these issues I have dealt with in the context of licensing in Australia and in Singapore, where ultimately you end up with an impasse between a private operator and the state regulator. Next slide, please. So to conclude, the take-home points of what I have been saying and what I want to say is that some states, as time go on, they need to consider revising their existing space laws in order to regulate non-launch activities or non-launching state activities where appropriate, to ensure that their obligations under Article 6 to authorize and continually supervise is met, and also that if they want to pass on the liability to the private operator, that they've actually captured the full range of international liability under the Outer Space Treaty. States that haven't yet drafted space laws and are in the process or plan on drafting new space laws do need to take issues beyond launch liability into account. They need to consider their responsibilities under Article 6, not just in terms of licensing and regulation, but also in terms of liability. There are some states, and I know this from practice and experience, there are states that don't yet have national space laws and try to bootstrap, what I call bootstrap anyway, terms and conditions on other licenses to indirectly regulate these space activities, for example, by issuing radio frequency licenses. They often don't work, and they're very often subject to legal challenges, and in the absence of actually thinking through what they're trying to regulate in their terms and conditions of licenses, often result in a private entity being impossible in being able to meet those conditions. The fourth, and most importantly, particularly for the sake of my wallet, we obviously need more and more space lawyers who are not just skilled and knowledgeable in the field of space law, but also with the experience in a practical sense to be able to guide and assist governments in both drafting, enacting, and applying national space laws that would be adequate on a commercial level. Thank you very much. That concludes my presentation. I'm sorry to say that I can't stay till the end of the session because I have a conflicting engagement. Would it be possible, if it is preferable for, I'm happy to answer a few questions now if there are some urgent burning ones. My email address and is on that last slide. I'm also on Twitter. Feel free to tweet at me if you have any questions. I certainly don't want to take up too much of Professor Hoffman's time, but I'm also mindful that some of you may have some questions that you may want to ask, and I know that the topic I've covered is not exactly an easy one. Thank you very much.
Okay, great. So good afternoon to everyone. First, I would like to thank the organizers for this very kind invitation. It's a great pleasure to participate in such high-level conference. Second, I would like to express my respect to the space activities of India, which are really enormous and which we are following with enormous interest. Let me to lead you to a small country in the center of Europe, to the Grand Duchy of Luxembourg, which has completely different structure than is the Indian space sector, and which decided to create a welcoming environment for the operators of space activities. And I would like to use this opportunity to share with you some experience on the work on two legislatory acts. The first one, the legislatory act on space resources, but we shall concentrate mostly to the most recent one, which is the General Space Law of Luxembourg. In the side remark, I would like to say that we have two master programs in Luxembourg dealing with space activities. One is concentrated specifically on the legal issues, and another one is an interdisciplinary space master. So let me to lead you to the government of Luxembourg. Next slide, please. Which decided to accommodate its legislation to the extended space activities. So the space activities of Luxembourg started to expand at the beginning of the 2000, and then the legal framework did not correspond to the needs. Why? Because there was only one legislation, the law on electronic media, which allowed to authorize only one part of the Luxembourgish space activities, and it was the satellite systems. It was the launching of the SES Astra satellites, which were using the Luxembourgish frequencies. Other space activities could not have been licensed under this law because, as we said, it was accommodated to authorize only satellite systems. So the first step which was deliberated was that with the arrival of space operators, please the former slide still, I'm still on the first one. The former one, please. Does not matter. So it was a necessity to create the legal basis which would allow to implement Article 6 of the Outer Space Treaty. So we are speaking about two legislations which were adopted in parallel. So I have been asked to report here on the general space law, but we should also remind, in order to avoid a confusion, that in parallel there was speedily created a specific law which enabled to authorize space resources activities. At that time, several companies settled down in Luxembourg, and the operators needed to have the security, the guarantee that they could operate, that their activities would not be considered to be illegal. And that's why the first law, the law on space resources, was adopted already in 2017. Great. Now Luxembourg had two legislations, one for space satellite systems, another one for space resources. But what about the remaining space activities, such like on-orbit services or launching CubeSats? it could be also interesting not only for commercial companies, but it could be interesting also for the university, which also has projects and prepares some satellites which should be launched together with the students. So for this category of activities, there was any legal provision except of the Outer Space Treaty, which is directly applicable in Luxembourg. Good, so the government said, we cannot let it like this, we need a broader legal basis, and the government started elaborating a draft on the general space law. So the first law was adopted was submitted to the parliament in 2018, and then the government was waiting for the reaction of a specific body in Luxembourg, which is called Council of the State, and it is something like constitutional court in other states. So it is a body which is responsible for checking the compliance of each draft law with the Luxembourg Constitution. So this Council of State really analyzed each and every provision of the draft of the General Space Law and came to one specific conclusion. It said that as long as there is the law on space resources, it would be unwise to have two regimes which are completely differing. So the Council of State said, let's harmonize these two legislations, because otherwise it would be confusing and it would be also floor for picking up the legislation which seems to be the most suitable. So let's harmonize all these two legal acts to have a consistent approach. So the whole draft, which was elaborated under the auspices of another ministry than the law on space resources, had to be reworked. So it took some months of work to achieve that both legislations are compatible. And then in this legislation was finally adopted by the parliament in 2020. It was signed by the head of state on 15th of December and entered into force on the 1st of January 2021. The next slide, please. Thank you. No, this one exactly. So, what is the result of this work? So, the law was you see here the source of the law, the place where it can be found in the legislation. We have to say that the language of the legislation is Luxembourg is in French. So here you will find the French original version of this law. And so first, what is the material scope? So material scope of this legislation are space activities of Luxembourg, meaning launching, meaning of controlling of space objects, meaning of using space objects, and including their return to the Earth. Exempted from the scope are space resources missions, because, as we said, these are covered by the 2017 law on space resources. What is the territorial scope? So here the law is covering space activities from the Luxembourg territory, which are carried out from the Luxembourg territory. But as we said, Luxembourg is not very extensive country, so there are not so many which would take place directly from Luxembourg territory. Most probably there would be never a launching facility in Luxembourg. But they are also the law covers also the space activities which are carried out from the installations under the jurisdiction of Luxembourg. And here the law has in mind that also the, for instance, launching from sea platforms or from airplanes under the jurisdiction of Luxembourg would be included under the territorial scope of this legislation. And also in other places carried out by Luxembourg nationals, natural and legal persons. So it does the law does not deal only with legal persons, but also natural ones. What is the temporal scope? So they are covered activities which are started after 1st January 2001. But of course, they are transitory articles which deal with those activities which have been already licensed under the previous electronic media law. So here there is a solution. I am not going into the detail in this spot, but of course, with pleasure, I would respond any questions to this. So an important provision is that all activities covered by the law have to comply with international obligations of Luxembourg. You can ask which one are there. So Luxembourg is party of the Outer Space Treaty, of the Liability Convention, and also with the Registration Convention recently. It deliberates also to adhere to the astronauts and rescue of astronauts convention soon. It is not a party of the Moon Agreement. And then what about the substantive provision? So the core of the law is the authorization of space activities and its regime. So they are, let's say, 15 articles which deal with the conditions of the authorization. And as we said, they are almost copied now from the authorization regime of space resources law, because as the Council of State rightly pointed out, they should not be different regime in one small state. So what are the conditions? I picked up only a couple of examples. So the person has to have its seat in Luxembourg, and the conditions as the honorability or the technical experience and financial soundness are taken over, in fact, from the law for establishing financial institutions in Luxembourg. So they are really very strict, and they correspond to the conditions for establishing a credit institution, for instance. What is quite interesting, I think, and it makes the law perhaps different from other legislations like the Belgian one or the Austrian one, the operators have to insure their activities. So there is a mandatory insurance. There is no escape clause which would give the government the possibility to excuse from the insurance, and also the operator has to pay an annual fee which is between 2,000 and 50,000 euro per annum. Also, a specific provision says that the operators have a full liability for damage they cause. So there is no cap on liability, again, different to, for instance, the French law or to the law of Austria. The next slide, please. Thank you. So I would like to give the floor to your questions. To sum up, I would like to say that once more, the recent law covers space activities other than space resources missions. Space resources missions are covered by an early law from 2017. The operators who are applying for the authorization may need further licenses, as my colleague Professor Ekeli said, also for using specific frequencies, because it's clear that almost no space activity can be carried out without having access to the radio spectrum. So at the moment, the government is discussing how to make the two application procedures smooth, and how to help the operators not to face complicated parallel conditions for obtaining the access to spectrum. But still, the operator at the moment needs to apply for the use of frequencies. And what I find quite interesting, in the original draft of the law, there was specific provision dealing with space debris and the protection of environment. They are not included in the final text of this recent legislation, also because of the harmonizing with the 2017 law on space resources. But as I was said by my colleagues in the Luxembourg Space Agency, these can be included in the authorization procedure, which should be adapted to the scale of the risk expected. So if submitting the application for authorization, the government may ask the operator how he or she deals with the debris mitigations problem. And then there is, if also the environmental provisions can be taken into account through the bridge of the compliance, the duty to comply with international obligations, because by this the operators are also obliged to comply with Article 9 of the Outer Space Treaty. No need to explain the details. The law also has established a national registry of space objects, which was the condition for ratifying the 1975 registration convention. So what are the advantages of this law? The law explains the operators in a transparent way what are the conditions for application, and also what are the sanctions for violating the conditions of the law. I haven't mentioned it, but it is a fee or even the imprisonment which can be imposed on the operator if he or she carried out space activity without having authorization. And at the moment, the government is preparing the secondary legislation, which would explain the details of the procedure if necessary for the operators. So let me finish my short introduction in this moment. I am very much open to your discussion, and also to being contacted by you per email to stay in touch and to help perhaps to understand more details of this procedure. I am staying in this blog, so you can also raise your question after in the question and answers session. Thank you for your attention.